Hello there. My name's Ian Spence. I'm the head of anti-money laundering and countering the finance of terrorism in the FSA. Today, we're going to be talking about beneficial ownership and how the work of the FSA and DFE operate within that. Just some background to start with. Why do we talk about beneficial ownership in relation to anti-money laundering? We talk about it because the Financial Action Task Force International Standards Setting for AML/CFT has a significant recommendation, number 24, and an immediate outcome 5 in relation to each country protecting itself through the control of people who run, operate, or own legal entities such as companies. FATF itself has quite a significant range of guidance out there for you to read if you need it for more detail, and recently have been consulting on changes to that recommendation 24 guidance just to try and keep it up to date. All of that sets out the expectations of what each country should do, and in Isle of Man we have the Beneficial Ownership Act, which brings those expectations into law, brings the obligations in for a number of people in relation to Isle of Man legal entities. The whole point of beneficial ownership and the transparency of ownership is to try and prevent people from hiding their identity, particularly criminals, terrorist financiers and others, behind companies and using company names or shell companies. And the whole point of a register and keeping that information available is so that law enforcement and other competent authorities can quickly identify who really is involved in the company. So, in Isle of Man, the Beneficial Ownership Act Section 4 defines what we mean by a beneficial owner. As you can see on the screen, we're looking at natural persons. So these are individuals, humans. So not the entities themselves. We're looking at a natural person who ultimately owns or controls a legal entity. And we're looking at their proportion of control as being an indicator of who really is behind each of the companies. We're looking at direct or indirect ownership, whether that's through ownership of shares, voting rights, or other ownership interests, and other people who exercise control even if they don't own the shares themselves. The other element to the law is that we expect this to be identified and verified no matter what set of structures, entities, trusts, foundations, or individuals are involved in the chain of ownership. So we're not just looking at the legal entity itself, we're looking at the structures behind it in terms of identifying who the real beneficial owners are. So again, any and all natural persons who have ownership and control have to be considered in relation to this to work out who really controls the business. It needs to be traced through any complex structures, any chain of companies, any international chain of company structures or nominees. And in Isle of Man, limited companies, limited liability companies, foundations, some limited partnerships are all covered by the Beneficial Ownership Act. For all of those entities, we need you to have the required details. And the required details are quite simple. The name of the beneficial owner, their date of birth, their usual residential address, a service address, if it's different from the residential address, when they came into that interest, that ownership, or whatever, of the company, and what proportion of the company they have control of. To help you, we have FSA Guidance. It's on our website. It's been in place since 2017, since the Act came out, which can help you decide and identify who the beneficial owners are in a number of different scenarios and diagrams. One example is actually set out in the law, and it talks about intermediate owners, and it's just an example to help you think about who might be involved in the ownership or control of a company. So in this example, the legal owner, that's the person who owns the shares in company A on behalf of another individual, X. X is a nominee or a bare trustee for another entity, in this case, Y. Just to complicate matters, Y is a nominee or bare trustee for the real beneficial owner. So, let you see that for a second, because it is quite complicated to start with. So the legal owner holds the shares in Company A on behalf of X. X himself is a nominee for a bare trustee for Y. And Y is a nominee for a bare trustee for the beneficial owner. So we have a chain of individuals, each holding an interest. But in this scenario, X and Y are not the ultimate beneficial ownership. They are intermediate owners. And there are obligations in the Act for a number of people, including intermediate owners. But as I said, there are examples in the law and in the guidance put out by the FSA to help you work out who or what has the interest in the company. The way it's done in law is to place a lot of responsibility onto a person called the nominated officer. Every Isle of Man legal entity is required under the law to have a nominated officer. Yeah? And later on we'll talk about TCSPs, but you can think of TCSPs, corporate service providers, as being the corporate version of a nominated officer. The obligations are very similar, but throughout this we'll talk about the nominated officer's obligations as meaning the individual nominated officer or a corporate service provider acting as the nominated officer. So the nominated officer is required to evidence all of the owners, legal and beneficial, in the legal entity, to maintain and preserve all of the evidence and the records in relation to that, and be available at any time when called upon by law enforcement or the FIU or another competent authority to provide the information on all of the beneficial owners of that entity. And normally there's a retention period of about 5 years after the point at which the information is no longer valid, just so that there's a bit of historic record on who owned the company at any given time. So the nominated officer has to get evidence of every owner, legal and beneficial, in relation to the company. And once they have all of that, so once they've obtained all of that, they then need to review that evidence to identify how many, if anyone, has more than 25% beneficial ownership in the company. Yeah? So evidence of everyone involved in the ownership and control of the company, and then within that, try to identify those who have more than a 25% interest. The nominated officer is legally required to take all reasonable steps. We shan't be going into detail of what reasonable might be today, but I think you can safely say we would expect to see some effort and the evidence and a third-party verification of information as being the reasonable approach by a nominated officer in a complex case to work out who really owns the company. In simple cases, so in terms of owner-operator companies, it's very easy because the person who runs the small Isle of Man business may well be the person who set it up, owns all the shares, and is the beneficial owner, and may act as their own nominated officer. So those cases are very simple and should be very simple to evidence and confirm. TCSPs, for example, might be involved in more complex and international structures, and therefore it's more difficult for them and the more efforts required for them to identify who the real beneficial owners are. In parallel to the Beneficial Ownership Act, CSPs, TCSPs, are also required under the Anti-Money Laundering, Countering Financial Terrorism Code to identify ultimate beneficial owners of any customer that they're acting for. So we have parallel legislation for them which both require the nominated officer to look through any complex structures and find out who the ultimate owner and controller is. If the nominated officer is struggling to get that information, they have legal powers under the Act to issue formal notices to the legal owner, that's the person who owns the shares, the beneficial owner, the person they believe has actually got the beneficial ownership of the firm, or any intermediate owners to provide the information. So that's a legal power for the nominated officer to require the information of those people. And clearly, if they don't provide it, the nominated officer can then escalate that legally to the FSA, as we have oversight powers under the Act. So, the plural nominated officer has worked out through all of these structures and organisations who owns the shares as a nominee or a trustee or as a beneficial owner. We now then have to identify those who have a registerable interest, that's those with more than 25% interest in the firm. And once they've identified those, nominated officers must record all of that detail into a central registry in Isle of Man. The central registry is called the Beneficial Ownership Database, and it's run by Central Registry in parallel with companies' registers. A registerable beneficial owner can only be a natural person. It cannot be a company or a trust or a foundation, because the whole point is to identify the individuals who actually have got control of these entities. FSA Guidance, once again, sets out some diagrams, and we'll see one in a minute, sets out some diagrams to help you consider who you've got, who is the registerable owner, and who is the beneficial owner. Nominated officers are also required to keep all that information up to date. So every year, the legal entity and the nominated officer must make a legal declaration that the information submitted and on the register is accurate and up to date. So nominated officers and the legal owners and beneficial owners still have to keep in contact to make sure they've got the information up to date. I said a minute ago we'd look at one of the diagrams, and this is one from our FSA guidance. As I said earlier, we've got some simple structures. Owner-operator business is probably the simplest ones, where the shareholder, the beneficial owner are the same people, and therefore they're easy to identify and record. This structure here has a slightly more complicated structure. So in this diagram, Company C is the Isle of Man Limited Company. The shares in Company C are actually owned by a trust. And that trust has trustees. The trustees in this case happen to work for a corporate service provider, a corporate trustee. And looking above that, in this scenario, we have two shareholders in the corporate trustee, shareholder X, shareholder Y, who each own 50% of the shares. So in terms of legal ownership, shareholder X and shareholder Y are legal owners of more than 25% each, and therefore they are registerable beneficial ownerships through their legal ownership. We then look at the others involved here, and here we're looking at beneficial ownership and beneficiaries of the trust, and we have 4. Now, assuming that beneficiary B, C, and D are individuals and not the same person or connected in other ways, they only have a 20% interest in that trust, and therefore they cannot have more than a 25% interest in Company C. So although they are beneficiaries and beneficial owners in the company, they are not registerable. Beneficiary A, however, may be a registerable beneficial owner. And that depends on whether or not they have more than 25%. In this case, they have 40%, and therefore the nominated officer should start with the premise that they are a registerable beneficial owner. So straight away, we appear to have at least 3 beneficial owners who need to be captured in the database. The law, however, also requires nominated officers to capture those beneficial owners who are beneficial owners through their control of the company. And that may be someone who's not a shareholder and not listed as the beneficiary in the trust, but they may themselves have control over the trust through other means or other arrangements. And so although the diagrams suggest that we should have 3, in really complex structures, the corporate service providers have to look beyond the paper trail and try to establish if there are any other people who really control what happens with the company, and in this case, what happens with the trust. But at least the diagrams help you try to settle most of the complex structures that you'll find. So, CSPs in the Isle of Man are vitally important to make sure that our beneficial ownership details, data and information is up to date and transparent. When law enforcement look at the structures in the Isle of Man, when international law enforcement look at the structures in the Isle of Man, they want to see transparency. The threat to the Isle of Man isn't so much from the activities that we undertake here, but the threat is the perception that an offshore international financial centre deliberately hides the identity of those involved in companies or shell companies, and therefore hides the ownership of assets, of businesses, of money. As you've seen through this year with Russian sanctions, a lot of media coverage has come out on where those oligarchs have got their assets, what assets they own, how they hide the identity of the ownership of those assets. The same applies when we look at some international criminals or international organised crime or some international politically exposed persons, where again the risk is that people perceive the Isle of Man as hiding and assisting them to hide illicit money. So for CSPs who generally are involved in more complex structures, if they're providing Class 4 regulated corporate service to a customer, they take the place of the nominated officer in the law. They must be able to identify and evidence the beneficial ownership of the entity through complex structures, because that's what the law requires them to do, and that's what the Isle of Man requires to make sure we've got transparency and the ability to see through complex structures. As I said earlier, legal powers in the nominated officer to challenge legal intermediate and beneficial owners for evidence and verifiable evidence to confirm who really controls the business. And the CSP, as the nominated officer, must submit registerable details into the database and keep it up to date and accurate. When law enforcement do look at legal entities, or where competent authorities do look at legal entities, the first person they will contact for information will be the nominated officer. In complex cases, that's likely to be the CSP. And there are legal obligations on that nominated officer to be able to produce the information and the evidence and the verification of that evidence to law enforcement. And there are time limits for that. For registerable beneficial ownership, it's within 7 days. For unregisterable beneficial owners, so those that don't have 25% more, it's 30 days. But as you can imagine, when the FIU or the police or the authority come looking for information, we're going to be looking for it as fast as we possibly can, rather than waiting till that deadline is met. If all of this sounds like bureaucracy to you, can I just say it's vitally important around the world in the fight against corruption, in the fight against hiding corrupt funds, in the fight against hiding illicit funds being laundered or terrorist finance funds, that we have an ability to chase the trail of ownership, to identify who owns what. Yeah. Otherwise, it becomes much easier for those criminals to hide their money or move their money or use that money for even worse purposes than just money laundering. So, on island, we have two main agencies involved in the beneficial ownership data. The primary one is the DFE Central Registry. Yeah. They're responsible for the database itself. So they technically run the database and the administration of the database and all the technical aspects that they need to have that database run properly. Nominated officers are required to put the information to them through an online portal. So I'm afraid all the IT side of it is run by our friends in DFE. The oversight of compliance with the Act falls to the Financial Services Authority. So we have twin roles here, DFE for getting the information and accurate information into the database, and the FSA responsible for making sure that people comply with their obligations under the Act. 2 years ago, an exercise was run to look at the data quality in the database, and safe to say, it was very poor. There were significant gaps in entries. There were significant errors in entries. There was information in some of the entries which clearly were not right. As a result, DFE have run a significant data quality project and have brought in data analysts and data specialists to try and drive up the quality of the information that's in the database. And the law changed in 2021 to allow them to challenge and change information which is clearly wrong. we're starting to see the results and the improvements from that project. But it was always going to be the case that no matter how hard they tried, there would be some cases which they could not resolve by asking people nicely to fix the data. So what we have in place now is a referral system where, having identified that there's an issue in the data they've got, registry will then contact the business asking them to check and update that information. If that doesn't resolve the question, they will go back a second time and remind the firm again that that information appears to be wrong and needs to be updated or changed. And if that does not happen, they will then place the firm in default in company's registry and refer the case across to the FSA. So we have a significant number of referrals each month which come across, which say, we have tried to get this fixed, we haven't got it fixed, we've made contact 2 or 3 times with the business, I'm afraid you're going to have to think about compliance now. The majority of the new cases that we see tend to be newly created companies. And we admit that there is a gap in the systems and processes that when you create a company on company's registry and get your certificate of incorporation, that's only half the job. And unfortunately, the second half of the job, the beneficial ownership database, is sometimes forgotten by people. Or perhaps they just didn't realise in the first place. So there are 2 stages to incorporation. One is to get the information onto the co-reg company's register, and secondly, to go into the portal and add the beneficial ownership details. And a lot of the referrals we get are from people who were unaware that they needed to go into the beneficial ownership database, or they had forgotten even though they read the paperwork at registration. So, registry trying their best and encouraging what's going on. FSA now also trying our best to get the message out. And part of that messaging is this webinar, to try and encourage those involved in companies to get the information onto the database and actually make the information much better. In addition to the existing database, DFE have been working hard on a new improved database. A significant spend in IT and developers has built a far more robust database, registry if you prefer, with improved controls and improved field controls to prevent unnecessary errors in there. They've also built some tools in to help them identify where people have got slightly different versions of their name recorded in different parts of it, to try and make sure we've got consistency of what people are called, or whether they use their full name or part of their name or middle names, etc. And the same with addresses, to try and ensure that we have one version of each address in the system rather than multiple versions of it. So a much improved system is running at the moment. It has built into it identity and verification elements, automated ID and V verification elements. To be fair, those have not been turned on as yet, but they are ready to go as and when they are needed. So that database run by DFE, we're trying our best to try and make sure that information is accurate and up to date. And for most CSPs, we would expect you to know and be able to get that information correct. So, what are we doing? In 2023, partly because of the referrals that we have coming across, partly because of the poor historic data quality, and partly because the oversight of the Act does actually expect people to be checked on the information that they provide, the FSA is actually going to start more inspections into companies and the beneficial ownership recorded in the database than we have before. Part of the reason for that is that having a database and having a register is not enough evidence that the Isle of Man is actually carrying the right information in there. The only way to make sure that we do that is to have some oversight, compliance, checking. Yeah. So in order to allow us to do that, we've actually looked again at the Beneficial Ownership Act and at the civil penalties for failure to meet obligations under that Ownership Act. And we've changed the civil penalty regulations. what we've done with the civil penalty regulations is not create new offences, but what we have done is make sure that we have a civil option, if necessary, to deal with significant offences. Previously, our only route was to take people to court and take a criminal case for offences. So we've now have a mirror image of civil penalties approaches we can take, as well as the criminal ones. But we brought the civil penalties in because we didn't think that criminal prosecution was the answer in all cases. So, in terms of outreach, we're doing some webinars. We've spoken at Max State of the Nation. We've presented to the Association of Corporate Service Providers. Yeah. We have a publication page in Gallery this month, all of which is really us trying to beef up our outreach and getting the message out there. Our difficulty, however, is that although the corporate service providers are all registered with the FSA, we know who they are. Yeah? We can reach out to them. They are obliged under other legislation to meet legal obligations, and a number of them have multiple companies. The majority of Isle of Man companies are small Isle of Man firms, most of them owner-operator companies. We don't have details of all those individuals. They're not regulated or registered or designated business for any other purpose, and therefore they're less likely to be aware of their obligations under the Act. And we're less likely to have had any contact with them in the past. And what we don't want to do is scare everyone by coming out as the authority and bashing on people's doors to talk about this. So we're trying our best to encourage CSPs, accountants, lawyers, anyone involved in business who has a company or knows someone who has a company, to remind their clients or their family or their friends to have a look at that beneficial ownership database. And if they fail to put the information in there, to actually put it in, or to check that it's up to date, or if it needs corrected. Yeah. The more we can do with a bit of help from you, the less we need to come out and knock on doors and contact individual firms to actually go in and check the information. This doesn't mean that we're not reaching out to individual firms, but clearly the more channels and the more the range of approaches we have, the more chance we've got of people getting it right and checking it. And to be honest, for most people, once you've got the beneficial ownership details in there, most small Isle of Man companies, there'll be very little change year on year on year in that. So it may well be a one-off exercise just to get it corrected. As I said, we've started the programme, and the start of the programme has principally been with corporate service providers who have the most limited companies. Yeah. And the findings so far are relatively positive in that the nominated also CSPs do appear to have the evidence and the verification of evidence to identify all those with legal or beneficial ownership in the company. There are some slight glitches about what information they put into the register, but the good news is that at least they've got the evidence of who owns what, which is the real key to all of this. And we're working with some of those firms to adapt and correct some of the information that they put into the database. But so far, nothing horrible has been found. And I hope that's the way we continue, because the more we can evidence that the bulk of those companies are correctly captured in the beneficial ownership database, the more we'll be able to convince the outside world and assessors who come to look at the island for its robust protection for anti-money laundering that the information we hold is accurate and up to date. Without evidence and without the oversight evidence, that would be incredibly difficult to do, and the perception of the island as an island who hides identity of criminals and worse would continue. So there is a purpose to why we do it, even though I'm sure it's a pain for some of you involved. Finally, I know you've listened to this webinar, but you may well have other questions. So if you have a question about the database or the information that goes in the database or issues with the IT or the portal to log into that database, then you should send your inquiries to the inbox at Central Registry. It's on screen at the moment, so that's boainquiries.dfe@gov.im. If it's an issue to do with compliance with the Act itself, so beyond the register, complexity of arrangements, or issues getting information from legal or intermediate owners, etc., or just a technical question on how the Act applies to you, please send it to the FSA's beneficial ownership inbox, which is beneficial.ownership@ilmfsa.im. Thank now. I hope this has been useful.